He's the guy startups call when the stakes are high and the advice out there is dangerously wrong. Meet Rob Wells, former big law partner turned startup superhero. After years at one of the top IP firms in the world, Rob walked away on July 4th, his personal IP Independence Day, to found Rock IP, a firm laser focused on protecting innovations for the underdogs, inventors, founders, and makers who deserve a better than overpriced patents and broken promises. He's a strategic advisor who turns IP into real business leverage. And today, he's here to pull back the curtain on what founders really need to know about patents, trademarks, trade secrets, and how not to waste your first 20K. Buckle up. This isn't your average legal lecture. It's a crash course in protecting your ideas with one of the sharpest minds in the game. Let's welcome to the show, Rob Wells. Hey, Rob, how are you doing?
I'm awesome. Joel, that was an amazing intro. Thank you. I'm going to have to steal that and put it into my own stuff somewhere.
You know what? It's the first time in a long time I've done it the first take where we got it. So I'm just happy about that.
No, that was a fantastic intro. I appreciate that.
Oh, thank you.
Excited to be here.
It was amazing. You really excel the ballpark every time.
So Rob, I just want to go back, even in the intro, I mentioned this because this was something that really stuck out when we talked earlier, is you'd mentioned that your Independence Day was July 4th, 2017. What led you to leaving that big law firm and focusing on helping entrepreneurs and startups?
Yeah, that's, in my mind, I can still trace it right back. Let me paint just a quick picture. I was an associate. I was at a big, huge law firm. I worked at a firm where it was bet the firm stakes, right? Where you went there when you had to win or you were going out of business on patents, trademark, on intellectual property. And I was I was doing a bunch of litigation work, and that's what I really wanted to do, right? It's the kind of bright-eyed and bushy-tailed junior level associate. I wanted to really make a difference. That's, you think you can change the world. So I was in litigation. It was a big litigation. And at some point there, I learned that I was the junior associate on one out of 40 litigations between the two parties that were litigating worldwide, concurrent litigations. I realized I wasn't going to move the needle, right? I just didn't make a difference. And then I was similarly helping the first startup company that I had worked with. And they called me up one day after we had filed their very first patent application. And they said, "Hey, Rob, we just doubled our valuation with our banker just because you filed that." And all of a sudden, that was the warm fuzzy, right? That was all of a sudden I went, oh, I need to do something different here. I can make a difference, but I got to change it up. And so that's essentially how Rock IP was born. That was the starting point. I can make a difference. I can help a lot of people in a really big way, but not doing what I'm doing at the firm I'm at. So
what difference were you trying to make? When you came out of school and you went to that big law firm, what was the difference in your mind, in your young dream-filled mind?
Right.
What difference were you trying to make?
Yeah. So I had a college professor. My background's in electrical engineering, so I've got my undergraduate degree in electrical engineering, and I had a professor who built a system that went on the fuselage of an airplane, and then it could test and find faults in aircraft wiring. And she was just testing it out. That plane went to China, and when it came back from China, the device was no longer on the fuselage of the plane, and then all of a sudden, kind of that technology went everywhere. And she hadn't patented it. She didn't, she was still in development. She wasn't really thinking about IP. She's a college professor. But that was one of the big things I wanted to change. And at that point, I thought, it's the foreign companies. That's the problem. That's not really the problem, but that was in my head. It was like, oh, I went to China, came back they're stealing our technology. And so I decided I wanted to do ITC litigation. That's litigation at the International Trade Commission. And there we also do patent litigation, but there you can actually, if you win there, you can get an order to stop any infringing product at the border. So you're protecting the world's largest consumer market. That should be a big game changer, right? You should have a lot of impact there. But it became clear to me, I can really help the startup companies and really make a big difference there. And I found that same purpose in trying to help these startup companies that I thought that I was originally going for there at the ITC and the big law firms.
Yeah. So what I'm hearing is you wanted to make that difference on the macro level, but you realize that the real difference you make is on the micro.
That's a good way to put it. Yeah. Serving each individual client and making a big difference for each one of them, as opposed to just creating new law or, whatever have you. Yeah.
Yeah, man, I love that. I think that's a lot of what we do actually, and I don't. This podcast isn't about us, but a lot of like that's what we found is we want to help those small startup people, and it just makes a huge difference. Um,
But that's the thing, right? If you work for with a company like Amazon, like yeah, you get to you know work with this big conglomerate, but you know, Jeff Bezos is never gonna know my name. He's never gonna know I existed. He's not gonna see. And not that I need the credit, but it's like you just passed around from team to team, or the person that you're working under gets let go, and all your credibility is gone, and there's no real relationship built in the same way as when you're just working with a small startup, and you get to build that personal relationship and watch them grow and really bust your butt to make it happen, and then see that result. It's not like, oh, we just killed the project and then it goes on, like, and you're like, but I just spent 6 months going overboard trying to make this work for you guys. Like, it's a very different feel, and I think most of the people that we work with really prefer to work with the smaller startups too, like because it's a much more personable relationship.
Yeah. I mean, you hit on something that I think is really key, right? You know, it is all about relationship, and it's all about kind of at the end of the day having a finer touch. That's at least what Rock IP strives for. And one of the things that I really love about what I do is, and what I've got free days and focus days and buffer days. My focus days are dedicated to like sitting down with a client, figuring out and understanding their business, what they really want, and then figuring out how to support it with what I do. And I'm sure you do exactly the same thing. It's not just about like, okay, what did you just draw and let me make it. It's more of like, what do you really want here? What's the objective? What do you want to get out of it? Like, show me the picture of what you really want. And that comes through those personal relationships. I think you can get to know everybody at a startup company. It's much more difficult, like you said, to get to know everybody at Amazon, right? That's not to say that we wouldn't, be happy to work with larger companies too. It's just a matter of, I do enjoy the personal touch.
Right.
so when you're working with these startups, I mean, you've been privy to a whole bunch of startups and a whole bunch of ones that make mistakes and a whole bunch of ones that really succeed well.
Yeah.
What are the similarities between those that you see? These are the things that really help the startup succeed, and these are the ones that I see consistently that make them not succeed.
Yeah. So there's obviously startups come at different phases, right? The startup that's still at the friends and family stage, working out of mom's basement and cranking away, versus the startup that has got their round A or their round B, or and every other stage along the way, right? Whether they're getting their angel investing rounds, or whether they're trying to get their first round, their pre-seed round. Um, the things that I think make that kind of unify them are, um, figuring out who their people, like the right who, right? Figuring out who they should be turning to get advice, and then trusting that advice because they know they've got the right who. They know they have a partner who understands, and who's not trying to pull wool over their eyes, is more worried about them and more concerned about trying to support them than they are about trying to just make a buck for themselves. Um, and so, you know, when we have clients come to us, they come in at every spectrum in terms of their understanding of intellectual property, and at every spectrum of knowing what it is that they want to do with it. But one thing that unifies all of those in terms of the ones that succeed is when a CEO or a CTO comes to me and says, "Hey, Rob, like, help me understand this," and we explain it, and they go, "Yeah, that's exactly right," and let's go to town. As opposed to the other clients who kind of go, "Yeah, I got advice from this other guy who is telling us that, like, we just don't need patents." Okay. Um, then, like, why are we having the conversation? But, then people kind of suffer the consequences on that. We get told, on the trademark side, we get told all the time, like, I don't think we really need to worry about it. We'll see, like we'll see what happens, and then we get a call a couple of years later when they've got their first cease and desist letter because they didn't want to run a clearance search on something and make sure that they would own the rights, and now they've got really expensive decisions to make and damages to pay and losing branding and all that stuff. That doesn't mean that we shouldn't talk through things. That doesn't mean we shouldn't figure things out. But figuring out who you should trust and then actually trusting that person, I think, makes a whole lot of difference.
So how do you figure that out? Like, how do you learn who to trust in this game? Like, there's
Yeah,
so many people out there that say they're trustworthy. How do you know who to actually trust?
yeah. I think that at least for Ruck IP, we welcome and want our potential clients to sit down with us and let's have a conversation. Ask all your questions. I'll sit down for however long you want, and we'll go through IP 101. We'll explain the strategy. What you will start to see as we go through that conversation, unlike I think maybe some of like just the patent mills or the trademark mills that just kind of say like, all right, give us the details and here's your patent or here's your trademark or your application. Um, what you'll start to see is that I will ask you questions. And everybody that works with me will start to ask you questions to try to understand on multiple levels your technology, your business, your market, just all the way across. And all of a sudden, then you understand like they're not in this just for themselves. They actually do want to do and help me get what's best for my company or for my startup company. That's what they're leaning into. And I would say if you're talking to someone, whether it's a designer or a somebody who puts together your SEO or your website or a lawyer, uh, talking to somebody who tries to really understand your company and your objectives, that's what I think will help you understand like, oh, are they in it? Are they really worthy and worthwhile? And are they really going to serve me and help me? Or are they in it for themselves? And they're just saying that they're experienced.
Yeah. So what I'm hearing is make sure that it's actually a conversation. Make sure that they're actually listening to you before you hire them.
Yeah. And unfortunately it's a little bit like dating, right? Like sometimes you get to kiss a lot of frogs, unfortunately. But there are people out there who do care and I would say that also like people like us, I think we want to help each like that is our mentality. We want to be a part of really having capability and strength and caring about our clients. So once you find one of us, we're happy to tell you we know who else we've worked with in the past. And when somebody calls me and says, hey, I need somebody to help me design something, Brandon, you guys are at the top of my list, right? Like absolutely. So
So I want to also say this: when, especially with like IP attorneys or law stuff in general, what I've found is these big corporate companies are pretty much just like patent mills. They take no interest in your product or you or anything. They charge sometimes the most and produce the least. So at the very least, find a smaller firm that you get a personal interaction. Somebody where like Rob is like right where I would kind of position people. I'm not saying Rob's the only great option, but he's absolutely the kind of person that I like to see our clients work with. And that's just like as straight as I can shoot it. Like I totally think you got to stay away from those big whatever commercial you've seen. Probably not a good resource if they're running big commercials. Like just yeah.
we're talking about the entities that say, do you have an invention? Yeah. And we've
Or something like I mean even like Rocket Law or there's a Zoom this or I don't really want to call everybody out, but I've
yeah,
seen so many clients come to us that have, oh yeah, I got this patent and it's like not really worth the paper it's on. I mean, other than the fact that you can claim that you have the patent, you can have a patent number and it works for marketing and capital, but from my understanding of patents, it's not really worth anything in the court of law.
Yeah. So, I mean, we can talk about without calling anyone out because I agree, like there's no need to do that. But some of those entities, you know, we frequently get somebody who says, "Oh, we'll get a phone call from someone who will say, I have a patent." Really? Okay, great. That's fantastic. Like, let's take a look at the patent application. Like, or, can you give me the patent number? We'll look it up, and they don't have a patent. They have a provisional patent application, which is totally different from an actual issued patent. And what they don't understand is, and just because nobody explained it to them, all right, because it is kind of a mill in some of those situations. And they get told, like, oh, well, let's file a patent application. And they think that means, okay, now I've got a patent. What they don't understand is that when you file a provisional patent application, and we can get into all we can geek out. I'm happy to geek out about intellectual property. When you file a provisional patent application, that gives you 12 months to file a non-provisional patent application. The provisional, nobody is ever going to look at it. It's just on file at the USPTO. It essentially is a stick in the mud that holds what we call your priority date, the date at which you first told the patent office about the idea. And you have a choice then. You can just let it go. And in terms of strategy for startup companies, I love a provisional patent, and we can get into why. But you put your stick in the mud. 12 months away, you can either file that non-provisional or you can let it go. And if you file that provisional or that non-provisional application, then now you're going to get a patent application examined. But I've talked to so many clients, potential clients, people who call and think that they have a patent. And then I have to deliver the bad news that you actually don't have anything. And now that it's been over a year since you filed it, you really have nothing. You're even in a worse spot, because now you've actually disclosed the idea. It is on file at the USPTO. And so now we've got to make some decisions and figure out what we're going to do.
Is it
in order
true
to...
that I'm sorry, Chaos. Is it true that once it expires, you can no longer ever file on that idea again, so nobody can get a patent once that provision expires?
So it's not that nobody can file. So remember, when you file a provisional patent application, like I said, it doesn't. No examiner looks at it. From when you file it, it's not considered published. It is literally almost a secret, and you can't even if you had the application number, you can't put it in at the USPTO and pull it up. It'll come up. You put that number in, and unless you are the attorney or the individual who filed it, you can't find it. It'll just come up with an error. And it's not until a utility patent actually issues, and the one where you filed the non-provisional and then it issues, it's not until that point that you can actually pull up the provisional. So there are arguments that say, hey, you can file the provisional, and even if nothing happens there, even if you don't take advantage of it, you could go ahead and refile and include some of the same content as another provisional, or just don't claim priority to it. But what I would say is, aside from the provisional, if what you're trying to accomplish is, hey, I want to go ahead and put it out into the universe, into the world, so that everybody knows about my idea, so that nobody else can patent it, I don't really necessarily need the patent. I just want to disclose it. You could either just go ahead and put it up on the website, or file a non-provisional patent application to disclose all of that information, and then just don't care if you don't care about actually getting the patent. But once that expires, if you let it go abandoned, then you are kind of up a creek a bit.
Okay, and what about if you want to just do market research on an idea, right? You have a concept or a basic prototype, probably not what's going to market. Maybe it is. How can you get feedback on that without breaking the, I guess, the terms of public, right? It can't be public information. Is that correct for a patent? So you'd have to, like, is there a way to have people see it in a semi visual format, like, so you can get it across as many people as possible? Is it me just going face to face? Is that the best way to do it, or should I not do that either?
Are we trying to get like market research and trying to figure out what's going to work the best?
Like,
We're prototyping the thing.
Right.
Yeah. So like we're in beta essentially, right? Where we're just like, we're putting it out there. Okay. Yeah. So at the point where you're going to sell product, or you're going to actually put it out there into the world, the United States is a first inventor to file country in terms of patents. So what that means is that we give a patent to the first person who gets to the patent office, right? And what that means is essentially that you should, if you from the time that you get public disclosure, you have 1 year to file that non-provisional patent application.
Okay, so I can
So,
show it, and I still have a year as long as I'm the first one.
yeah, you do. Now, let me caveat that because I would be and nothing I'm saying here, by the way, gets to be counted as legal advice. But like,
Fair
I'm
enough.
not your attorney. But here becomes the problem, right? We're a first inventor to file country. That means if you tell me about it, if you're at a conference or whatever it is, and or you've put it in beta, or even you just told a few friends, right? And then somebody else takes that idea, sees it, takes the idea, and gets to the patent office with it and says, "Look at this great idea that I came up with." Now, if you go to court, they got there before you did. Good luck proving that you came up with it first and they stole it. But because we are a first inventor to file country, if you can prove they stole it from me, now they're not an inventor. And so then you would potentially win that. But
Yay.
from the perspective of trying to do the cheapest, like that is an expensive battle to fight. Why do that? Just get to the patent office first, disclose your idea, file the provisionals. And the reality is, one of the bad pieces of advice that a lot of startups can get is, two pieces of really bad advice. One, don't do anything until you have a patent in hand, an issued patent. That's terrible advice. You do that, and the market's going to pass you by, and you're going to sit on your hands and do nothing, and your burn rate is going to keep going, and you're going to just go bankrupt. So that's terrible advice. But the other piece of bad advice that people get is, don't worry about patents. They're worthless. They're not helpful. They can't help you. Nobody cares about your product. Just go to market. Just get out there and start selling it. That's also bad advice because patents and all intellectual property overall, it is property. It is, and at this point, there's Ocean Tomo has a, they keep updating the study that they did, but they've been following along with the value of the S&P 500 and how much of the value of the S&P 500 is in physical assets versus non-tangible assets.
Yeah.
And it used to, 50 years ago, it was a really low amount that was intangible property. Right now, 90% and probably more, 90% of the value of the S&P 500 is in intangible assets. 90%. That means almost everything you do. And as a startup company, you're looking at, okay, well, there's the technology, there's the thing I'm going to bring to market, there's how I'm going to do it, and then there's my brand. All of those things are intangible, right? Your brand is intangible. The actual technology or the innovation, all your research and development that you've put into creating this product, the product itself is a small part of that, right? The part that you're going to just replicate when you go to market. But the ideas behind it, those are the things that really is valuable and that should be protected. The misunderstanding I think that a lot of people have is they think, oh, it's patents or trademarks that's just insurance, or it's just a sunk cost. It's just a cost that I'm going to spend. And the misconception there is that it is just kind of a sunk expense. It's just kind of like on the negative side. The right way to view it is actually to take a look at it as an investment. And so there's a couple of things that go into play there. Number one, you shouldn't take your entire paycheck and put it all into the stock market. That's a terrible idea. So figuring out what the right budget is important. But the other thought there is, don't go after and get intellectual property just as an insurance. It's not just a shield. IP serves as a plowshare and a sword and a whole bunch of other things. It is another revenue stream. Take a look at like Apple and Google and everyone else. And IBM, massive IP filers, and they are making a lot of money on intellectual property. It's a full another revenue stream, and it would be a little foolish to overlook it.
So
Interesting.
you've been kind of talking about, you mentioned this a couple times now, where you was like startup strategy as far as IP. Can you just walk us through what a startup IP strategy should look like in your opinion?
Yeah. So, all right. So number one, not every IP, not every startup company needs a patent. Depends on, let's talk about what the product is. Let's talk about what you're going to market with, right? But every company needs two things, at least in terms of intellectual property. Every company needs a trademark, right? Because it's the brand, it is how everyone recognizes you. And you want to make sure you have a strong trademark. And then the other one is that every company should have a trade secret policy, and that's really overlooked.
I really want to hit on both of those. So when you say a strong trademark, what would make it a strong trademark?
Mm, yeah, I'm glad you asked that. So when we have we have what are called levels of distinctiveness, going from like the most fanciful trademarks, ones that are really really strong. Think in terms of strong trademarks that are fanciful. Think Pepsi, right? The name Pepsi, it's not a word that actually exists in any real language. So that's going to be one of the strongest marks. There's no one that's going to be even close. Take that by comparison. Let's take that and go. Let's drop that down to another term that may not be as strong. The term like the name Best Buy, right? It
Okay.
has become strong, right? It has become a strong mark. But when I just like when they first filed it, they couldn't even get that mark. They had to go to what's called the secondary register, which is one where you
Mm,
basically you take it and you say, hey, we're going to go after this mark and we're going to make it strong. Why like there are strategic reasons to potentially do that. But if you ask for my strategic advice, I would say pick what like I'm sure you guys are familiar with like the blue ocean or blue sky approach as opposed to like the red. Why get into the mix with a whole bunch of other names that are really close? Why not pick a name that's free and clear and open, and why not make it as distinctive as you possibly can, so that you have the ability to nobody else can kind of encroach on your turf. And then you do need to go ahead and make sure that you monitor and enforce it. But that's where we get to a strong trademark. To get a strong trademark, that begins with probably a naming project. So that's one where your marketing team or your executive team, if you don't have a marketing team, come up with 3 or 4 marks, 3 or 4 names that you really like. And then we'll go ahead and run a clearance search. We're checking on all 3 of those or 4 of those marks and trying to figure out, we'll rank order them in terms of their strength and in terms of other marks that might be out there. And then you've got one or two that kind of stand out, and you guys can pick. And then we'll run a full clearance search on the 1 or 2 that you've chosen, and then you go in knowing that whichever mark you've picked is actually going to be protectable. Oftentimes, startups and most other companies actually do it in reverse order. They kind of name their company, they get the website domain name, they go after it, and they are out there selling. And then they come to me and say, hey, Rob, can you get us a trademark? We can try, right? Like, but
yeah,
sometimes we end up delivering some bad news. And then there's a whole rebrand process that has to happen. And that's expensive and really frustrating.
yeah. I gotta say, like, I've not thought about using a lawyer or a trademark off. I've not thought about doing it in that order before. We focus a lot on patents and patent law, but you know, we just don't really pay much attention to the trademark side of things, probably as much as we should. And I'm curious uh, if our name would be trademarkable now, because it's something I was in the process of getting to, and um, yeah,
Yeah. So I mean, there's a lot that obviously a lot that goes into it, and MPD, is going to be an acronym, right? It's going to stand for and so we're going to have to potentially look into that, and obviously we're happy to help, um, but how strong is the mark? That all you do need to think about that and consider it. Trademarks is a great. We could make an entire episode all about trademark
yeah.
protection. There is that much information there,
Is
but
the I guess the question I have is the trademark is not just the name but the logo as well, right?
Mm. Yeah, so I mean, this is becoming a trademark discussion, and I'm happy to have it. But trademarks can come in multiple different flavors, but the most basic is what we call a character mark. That is a mark that protects just the words, right? No font, no stylization, no color, nothing. It would just be MPD. No organization, no like, oh, I've got this on top of it, like nothing like that, right? It's just MPD, right? Or just Rock IP. You look at my logo back there. It's just Rock IP. That's it. Um, and it's the most basic. And anybody who uses it, no matter what format they put it in, if they, change the font on my logo or your logo, it wouldn't really matter. You'd still have rights to that trademark. But then you move into design marks. And in a design mark, we are talking about what does it look like? What, potentially what the color is, what's the layout, what's the orientation? Are there other elements that are not just words, but are, they got chevrons or, a bird, or like if we're talking about Twitter, or, the Pepsi logo or whatever it is. Those go within a design logo, a design mark. Have you thought about any of the marks? Are you aware that there's things that are not just logos that get considered trademarks?
We know nothing by the sounds of things.
All right.
This
So
is
this is
my
cool.
expertise.
No, so check this out. There's other things that are trademarkable that you probably would recognize, uh, like for example, do you know that there's smell marks, scent marks?
I was wondering about
Trademark
that.
of
I
sense?
know art can be earned, but I mean, it makes sense that you would be able to do like maybe flavors and scents.
Yeah. So, and I can show you. Have you ever opened up a can of Play-Doh? Do you know that smell, right? That
Yeah.
smell is
Very
trademarked.
distinct.
Absolutely trademarked. And have you opened a generic can of Play-Doh, like that's not like Play-Doh, just the sand or like the whatever?
Mm.
It doesn't smell the same, right? Or if your mom made Play-Doh for you when you were a kid, like, uh, and I should probably stop using the term Play-Doh because that is trademarks, but that you know what I'm talking about though, right? Like the squishy
Putty,
stuff.
moldable putty.
Yeah, what like the play putty, right? Um, so that like it doesn't smell the same. That scent is trademarked. Colors can also be trademarked. So, for example, and typically these are going to end up being more towards the more feminine, but Tiffany's blue, that blue box
Right.
that your girlfriend or your wife wants, that's trademarked. Tiffany's blue is trademarked. The other one is like the red sole on a woman's high heeled shoe. So it's trademarked by Louboutin.
Mhm.
And so, you can't just get a shoe and have red on the bottom of it because Louboutin will send you a cease and desist letter. In terms of insulation, that pink insulation, that's trademarked. It's a
Really?
particular color. Yep.
That makes a lot of sense. We just renovated our house, and there's the pink one, and then everything else is like white or off-white,
Mm-hmm.
and it's just interesting.
Yeah.
Yeah.
And then there's sound marks. So a sound mark, like think about what's the sound that you hear right when you log into Netflix.
Yep, I was just
Yep.
thinking that exact one.
That sound, right? Like that's a trademark. And the NBC or the CBS chimes or what, like every one of them, they've got their own little sound mark that gets covered.
So going into that, if because the Netflix, that is the one of the most iconic in my opinion, but people use that in videos all the time,
Mhm.
like as someone hitting their head on a whatever, and then it goes dun dun, it goes Netflix logo. How enforceable is that when people are using it all the time in short videos?
Yeah. Well, now you're getting into the question of what is fair use. And so remember that the purpose of a trademark, the value, like the reason we created the trademark system is because we're trying to protect the public. Now, that's in contrast to what we do with patents. But in terms of the public, in terms of trademarks, we're trying to protect the public and the public's ability to recognize the source of goods or services. So think about like, have you guys seen Coming to America, the movie? Like I might be
A
dating
long
myself here.
time ago.
Yeah, well, I mean, it's an old movie, but um, the the thought there, do you remember they had like the restaurant that Eddie Murphy worked at with like the big golden arches, right? But it was like McDuffie's, or I can't even remember the name of it. It was not McDonald's, right?
It was
That would be a trademark
eerily similar
infringement.
yet legally distinct.
You get confused, right? Like the customer gets confused. They come in and order for like, what would you feel like if you pulled into this drive-through with these great big huge golden arches, and then the person opens up the drive-through window and you're try to order some fries, and she goes, "I'm sorry, we sell tires here." You'd be frustrated and confused, right? Like, so that's what trademarks originally gets put in place to, and that's you do have value in owning the trademark and building the brand, right? Because you now own that brand, but the purpose is to support the public's ability to recognize the source of your goods or services. So, and I've gone kind of far afield there. But the purpose of, when you're saying like, oh, it's in YouTube videos or somebody, like they're making fun of the sound, they're not trying to sell a product or a service by using that sound that way, right? They're sort of satirically using it, or they're making fun of it, or they may be talking specifically about Netflix. Those are all fair use. You can use those things, just in order to make to make a funny, to laugh about it, to joke about it, to make something satirical, like somebody hitting their head and then hearing the Netflix sound. That's just satire, and that's fair use. But if you tried to use that sound on your podcast to like sell your podcast, or so that people would recognize, oh, this is associated with Netflix, that would be a problem.
Okay, that makes a lot of sense.
Yeah, I appreciate that. That was a really cool
So
bite of information there. More than a bite, but yeah.
That's a lot. I apologize. Like, feel
No,
free to
it's
tell
good.
me
It's
at
good
any point in time.
information. Yeah, I was aware about the colors. And it makes sense that I knew music, but yeah, it makes sense that they do with so I thought, well, actually, I was thinking that one fell under copy. No, music's under copyright, right? That would be under copyright, not under a trademark. But the bing bing, the entry sounds would be okay. Gotcha. That makes
So you're
sense.
going to do two things with the Netflix sound mark. You're going to protect it under trademark as a sound mark, but you're also going to go ahead and get the copyright on it, right? Copyrights are fairly cheap, but a copyright covers basically any tangible embodiment of an artistic work. So whether that's code that you write for your software, or your embedded systems, or whatever it is, if it's the content that you put on your website, if it's a painting, if it's a dress, or a suit, textiles, all of those things, those will be covered under copyright. Same with like a recording of a particular sound, so like the Netflix chime.
So if you've got software, what makes it patentable and what makes it copyrightable? Like, where do those intersect?
Yeah. It's kind of a bit of a Venn diagram, right? And they overlap. You can get a copyright, so that's going to cover, and we should kind of say like everything by virtue of creating it is you have a copyright on it. The value of filing and going ahead and registering your copyright with the copyright office, like that you do so that there's advantages should anybody infringe it, right? You get presumed to be the copyright holder. It's demonstrable, and you can then go ahead and get like treble damages for infringement and that kind of thing. But in terms of patentability, on the patentability side to it, what you need is for it to be, the output of your code to result in something that is, A, it's novel, and B, it's non-obvious. And those are technical terms, but essentially it doesn't exist anywhere else. And then because you're asking specifically about software, let's kind of like take a look at the 10,000-pound gorilla in the room, because um, software has been more difficult to patent in the last 10 years than it ever was before. That's as a result of a big Supreme Court case. What the Supreme Court came down and said in that case, and then there's now a series of them, but in that particular case, they said, look, if you do something that's been done for ages, in that particular case, it was escrow. It was a case called Alice versus CLS Bank. And it was just, if you do something that has been done by paper and pen, or in the mind of somebody, or, tangibly, and you just say, I'm going to do it on a computer, you don't get a patent for that. You can't just get a patent by
Mhm.
doing something, even if you can do it faster, right? So that was seen at the time as kind of like, wow, maybe this is going to be the death knell for all software patents. It's not. As time has evolved, we've kind of figured out where those niches are. What you need to do is, if you can transform the efficiency of the computer, right? For example, there was a case where uh, somebody was taking it was called Eye for Eye versus Microsoft. And in that case, they were applying one single operation, not on a cell by cell basis, or on an entry by entry basis, but instead applying it to the entirety of the spreadsheet, or the entirety of the database all at once, running the one operation simultaneously across everything. And that resulted in more efficient computation, demonstrably more efficient computation. And so the courts then said, yeah, that is patentable. And in that case, Eye for Eye won that case.
You know,
Sorry, go ahead.
Honestly, I'm not really a software guy either, but there's a lot more things I'm not than things I am. Let's put it that way. But what about changing the way things like we communicate through software? Like, 'cause it seems like that's one of the biggest leverages I've seen with it's all social media. Like, all the biggest platforms have a social aspect to it,
Hmm.
right? Facebook, LinkedIn, Twitter. But then there's smaller ones too. Like even Duolingo has a big social aspect to it. Can the way that we are communicating with others socially be or no patented?
It certainly can be, but it has to be done under the right circumstances. You're not going to get a patent on just saying like talking on the internet, right? Like
Okay.
everybody talks, and we've been talking on the internet for longer than 20 years. So you're not going to get a patent on that. But if we can focus on a technological solution to a technological problem, for example,
Okay. So it has to be
then there
technological.
is a patent, the potential patent there, right? If there is some technical issue. So, for example, I would like I I happen to play the guitar. Usually have a guitar up in the background here, but um, I was during the pandemic. I really wanted to like play music with somebody else, and just like here, I'll strum, you sing. There's a delay, massive delay, right? Like it's just not possible. If you could come up with a way to actually make have no lag time, there would be a patent there, right? Like no lag time so that I can actually play over, like over our Zoom call or whatever it is, and you can sing and we all hear it at the same time. You'd be able to get a patent. Have you ever tried to sing happy birthday to somebody with a whole bunch of people and you're on Zoom and it's awful. It doesn't work
One
at all.
person is on time and the rest are about 2 seconds behind.
Yeah, exactly. Whoever starts it is going to be fine. And then they're going to second guess themselves because everybody else is lagging. And that, yeah, doesn't work. So if you
Hmm.
figured that out, there's a patent there.
What about the way that the notification is triggered? Like the
Which no,
source of what triggers a notification being you see what I'm saying? Like instead of like I mean, does it have to be specific around how the code works, or can it be the actual function that you're accomplishing? Is what I'm trying to ask.
so you're getting into like, we would have to get into more detail there,
Okay, I don't have more
but
details.
right. But there, what you're talking about is like potentially something that might be patentable from a utility patent perspective. But this,
Mm,
like, you've just segued me into geeking out with you again, because now I'm going to tell you that there's a difference between a utility patent and a design patent. You guys know what the difference is?
The
yeah,
utility patent is
confident.
about function, the design patent is about looks.
That's right. That's exactly right. Great. So a design patent covers the way that something looks and feels, the look and feel of something. The cell phone wars, for example, Apple and Samsung, right? They were fighting it out in court. That court case was all about a design patent, a smartphone with rounded corners, right? That's the one that Apple won against Samsung. Um, and that's why not the Pixel and other people kind of say, "Oh, my Android phone has rounded corners." Yeah, but it's not a Samsung. Take a look at any Samsung phone right now, and they all have very sharp edges because of that court case. Um, and so similarly, we can protect things like rollovers or the way that a notification pops up or the way that a transition operates. That can be covered with design patents. So in terms of what you're asking there, Brandon, what I would say is like, depending on what that actually looks like, we might be able to protect it with a utility patent, but we would probably also want to protect it with a design patent. And then we would just need to get
Gotcha.
into the details on exactly what that looks
Huh,
like.
interesting.
So I just want to kind of just shift the conversation just a wee bit.
Yeah.
Um, you had talked about how a client of yours doubled the valuation of their company just by you filing a patent.
Mm-hmm.
Can you kind of unpack that a bit for me?
Yeah. Yeah. No, this is a great story. And it is one of those areas where, um, where we, it's kind of the genesis story for Rock IP and for me making that transition out of saying like, I want to, be part of a really big law firm and make change that way, to me going, oh, I really want to do this. We filed one of my first startup clients. We drafted and we filed their very first patent application. And like all startup companies are doing, they're always trying to raise funds. So they've got a banker who's doing a valuation on the company, and so that they can take it over to the VCs or the angels to try to make more, try to raise some funds. And I was sitting down at dinner after we'd filed the very first one, and got a call from from the CTO. He called me. He said, "Rob, I'm going to tell you about this." I was just talking to the banker who was telling us we were valued at $2 million, and we were trying to figure out what might move the needle a little bit because we wanted to raise more. And I mentioned that just today we filed a patent application, and he went, "Wait, what?" And then, yeah, we filed our first patent application. It was a provisional patent application, by the way. And they said, tell us about it. Tell us a little bit about it. Kind of gave them bare details. Don't get too far into the details of your provisional patent application, by the way, with anyone outside of it, outside of your company. But gave them some bare bones details. And the banker said, "Huh, I think you double your valuation." Went from $2 million to $4 million on the basis, I'm sure there was more thought and calculation on the part of the banker, but the result was that that they doubled their valuation, which meant that they could now, that startup company, my client, can now raise twice as much money. They can now have twice as long a runway. They can actually, they have realized the value of their little investment, right? We spent, like, at that point, I don't even remember what we were charging for patents at that big firm that I was at, but filing us, that, call it $10,000, $15,000, whatever they spent on drafting and filing that thing. It really was an investment, right? Now they can raise twice as much money. So we took that company from 0 patents to 100. So yeah, value.
Wow.
Well,
So does it matter what's in like you said it was a provisional, like, obviously the banker couldn't tell you what was in that patent application, and probably neither could the CTO
The CTO
because
could, because he was named as the sole inventor on that particular one. So
okay.
he could have told you every single detail about it because I walked through every detail of it with him. But you're right. Like, so VCs come in. Let's just kind of look at the VC. The VC comes in 3 different flavors when it comes to intellectual property and their due diligence. One says, "I don't care about your IP," and I think this might be where that one of those areas where the bad IP advice comes from. They don't care about any of that. They really don't care about your product either, by the way. They care about your team. They want a demonstrated team. And it doesn't matter whether you're selling snow to Eskimos. They just want to know, has the team had successful exits before? Do I know that this team can pull this off? Have they overcome all those problems? So IP doesn't matter to them. You're not going to convince them that it does. The second set of VCs is, I think, probably 75% of the VCs that are out there. It is a checkbox. It's due diligence. They say, do you have IP? Do you have patents? Do you have trademarks? And if the answer to that is yes, check the box. That's a huge plus in your category. Let's keep going. We see that happen in Shark Tank all the time. If you guys ever watch it, right? The question comes up and they make their little pitch, and then one of the sharks will say, "Well, do you have patents?" "Yes, we do." "Great. No further questions," right? And as a patent attorney,
Can
I
you please
cringe a
detail
little.
all of your secrets that are in the patent for me on live TV?
Right. Yeah. Well, and then you got to go find it, and yeah, and it might be a provisional patent application, but but by virtue of filing a provisional patent application, even you can now say that your product or your service, probably not your service, but your product is patent pending, which is helpful, right? Like, now in your pitch deck, you can actually put that your product is patent pending. That's helpful. So
So what happened okay, so what happens if you're in this situation and then they actually deny your actual patent? So you've got the patent application, you say, "Hey, I'm patent pending," and you get your investment, and you get your round of funding, and then 12 or 4 years later, because that's how long it takes for a patent most of the time, it gets shut down.
yeah. Yeah. And look, that happens, right? We will help. It gets more expensive as you do more and more background research to try to find and make sure that you're getting something that is going to be patentable. And there's different reasons to do it. We can get into it, but when, let's say you file and the examiner comes back and has you dead to rights, right? Everything that you had invented, everything you described in your patent application, it's all there in one other patent reference that predates yours. And you kind of go, oh, shoot, right? Well, now, like, yeah, you don't have that. It's not, as soon as the patent application goes abandoned, you then can't say that you're patent pending anymore. So you might have to take that off and no longer say that you're patent pending. But like you said, that application and examination process can take a while. So, when you file your provisional, you get 12 months. And then even if you fast track so you're saying you're patent pending all the way through there with a provisional. And then when you file your non-provisional patent application, even if you fast track it, there is a system or a way to go ahead and get the patent office to examine your application faster. They promise that they'll get you to what's called final resolution. That doesn't mean that you know for sure whether you're going to get a patent or not, but they say that it's called final resolution and they get you there within 12 months. So that's great. What it essentially means is that they'll get you 2 office actions or an allowance within that 12-month period of time. Typically, your patent application won't even get examined for 18 months. Nobody's even going to pick it up for 18 months after you file. But even if you do fast track it, you're going to be able to say your patent pending for at least 2 years, right? Because the application hasn't got abandoned and you're provisional to non-provisional, and hopefully at least there you're able to utilize it for what a startup company needs that patent application for, and that is we're trying to protect our IP, protect what we're working on, but B, we're also trying to raise funds, and we're trying to establish ourselves in the marketplace, and we're trying to hold off competitors as much as we can, and being able to tell the world that this is patent pending does give competitors some pause, right? They may go ahead and look and see if they can find your patent application, but any sophisticated patent attorney is going to tell you, well, just because we couldn't find it doesn't mean that it's not there. If they're saying it's patent pending, it might just not be published yet. So they could have filed a provisional, or they might have filed the non-provisional, but it's not published yet. Even if you file a non-provisional, unless you take some other steps, it's not even published for 18 months. So for the first year and a half after you file a non-provisional patent application, nobody can find it. The result is that competitors tend to kind of steer clear or hold off for a little bit. Their race to get to the market is a bit slower, and that gives you precious time that all startup companies.
When you're doing your patent searches, right? Like before you go into all this, is that what you call them, a patent search, right?
There's tons of there's a few different things, but yeah.
200 or sometimes 200 pages worth of patents when you search like a specific thing. Are you reading through like 1,000 patents before you determine that it's a safe space, or is there maybe a more targeted way to do it, or is that what it really takes? Does it take you guys sitting down and going through like every single patent that could possibly like be related to that?
It,
Like, I was just curious. I didn't realize how many patents there was until recently when I just out of curiosity started to really dig a little bit more into that.
yeah, there are a lot of them, right? So here's the way this works. So what you're talking about is what we typically call either a patentability search or a landscape search. When we're
Mm-hmm.
doing specifically a patentability search, there is a possibility that we're going to come back with a lot of hits, a lot of different other patents that we then do need to kind of dig in and research. The most important part of that is going to be in the claims. I don't know if you've ever read through a patent before, if you've ever even seen one, but
I have a
they're
patent.
great. That's
Yeah.
fantastic. So you're aware there's like a summary, and there's figures, and then there is this lengthy description that we call the specification, and then at the very end, the last page or two, typically, there are what we call the claims.
Mm-hmm.
And a famous judge has said in one of his opinions, the name of the game is the claim. You can't enforce anything just because it's described in the specification. You really need to focus on the claims. In terms of patentability, we do care about what is in the specification, because if it's disclosed, that affects patentability. But
Yeah.
we'll start with the claims, right? We'll start by looking at claims and figure out what's there. What do other people have covered already? We can narrow the field a lot by talking about, by narrowing up exactly the most innovative feature or component of your system, or the apparatus or system that you're putting in place. And then what we look for is, okay, which ones get to like each and every one of the really critical, important, what we think is the innovation that we've got. And there are crowded spaces. They can get expensive. But frequently what I'll do is I'll try to say, give me the top 5 references. And those are the ones I look through. So we'll pay a few $1,000s to get a search that'll come back with maybe 100 different references. But the ones that I'll look through and actually spend time picking apart are going to be the 5 best. And the result there is that if the 5 best ones don't have your technology, like your specific innovation in it, we're probably going to be good to go. Doesn't mean we're not going to argue with the patent office, and it doesn't mean it's not going to be crowded, but it does mean I'm not going to spend your money on reviewing thousands of potential patent applications to
Okay,
try and weed it out.
gotcha. Yeah, that makes
All
a lot
right.
of sense.
So we're running on running pretty much out of time here, but I want to do what we call a lightning round, which is going to be about 5 or 6 questions here, and answer them as quickly as you can. If you need to expound, because I don't know patent, I'm not an IP attorney. Maybe there's one here that you need to expound on. You're welcome to.
Before we jump into there, there's one question that somebody's talked about earlier. I want to kind of jump back to. You mentioned that they reverse engineered the Google Nest thermostat in 24 hours. What do you say about the speed of IP in relation to that?
Yeah, no, that's a really good question. And what I would say is this. So let me just tell you the story. And I wish you hadn't given away the punchline, because it's even better when you don't tell people it's 24 hours. When the but but I'm going to add on to it, and I apologize if I take up too much time. When the Google Nest first came out, Google's engineers, a team of them, said, "I wonder how fast we can reverse engineer that." And they pulled together some of the patents and stuff, as well as getting a copy of the actual device. And they were able to reverse engineer it, fully manufacture every detail in a functional prototype within 24 hours. What that says is that, while we do want to race to market, you want to be first to market, and you want to actively get there, and try to control that for as long as you can. But the reality is, like, Google has really smart engineers. So does Apple. So there's a lot of people, a lot of companies that, once they're just copying and trying to recreate all of the R&D, all of the sweat and tear, trying to figure things out, that's all that work has been done. And so it's pretty easy, oftentimes, with intelligent people, and there's a lot of them out there, to just redo it, to like just create it again, right? And if it's not protected, then yeah, you run into problems. But here's part 2 of the story that I don't think you know yet. Part 2 of the story is Google acquired Nest. You probably know that. Do you know how much Google acquired Nest for? $3.2 billion. Before Nest had even turned a profit. And do you know why? The CEO has explained why they
The
bought
IP.
Google. What? IP. Nest had 100 issued patents and 200 more ready to be filed. And that was what Google purchased Nest for. Specifically, they wanted control over the technology related to, like, to like in-home and the hub. They were trying to get the Google Home type of system coming, and Nest's thermostat was going to act as a smart IoT hub. So Nest at that point had some patents surrounding that type of technology, and so that was one of the big reasons that Google purchased Nest. But you kind of look at that, and you're like, okay, well, number one, speed to market wouldn't have mattered, right? Like, if Google wanted to, and Nest didn't have patents, Google could have had that product up and competing within a very short period of time, right? Like, how much time do you need to actually get market coverage? Uh, Probably more time than they actually had. But because Nest had invested heavily in IP, again, it's an investment, not just an expense. They were then worth $3.2 billion. So there is the story of Google and the Nest, and why it's valuable to have intellectual property.
I love it. I love it. All right, so now we're going to go into the lightning round.
All right.
All right, so what is the biggest IP myth that you've heard consistently?
Biggest IP myth? Well, that it's just a cost. I mean, that's as simple as it gets, right? That's the biggest IP myth, like, that it's not important and not valuable, because it's an asset, it's property. And just like you can sell your home, you got a patent, you can sell it. You can do a lot of stuff with it.
Yeah. Okay. What patent do you admire the most?
Anyone that I've written. No, I'm kidding. You know, that's really, really tough because there's a lot of patents that are out there. But I really actually like some of the patents that were issued to the Wright brothers, not just on like the overall wing, or the over like
Hmm.
they invented a lot of stuff and they filed a lot of different patents. Um, by the way, I know someone who has a goal to try to have more patents issued to their name than Thomas Edison. So I looked it up. Any idea how many Thomas? And that's different than the Wright brothers. Any idea how many patents Thomas Edison has?
I'm supposed to be the one asking the
Gotta be
questions.
Sorry,
thousands.
No.
I mean, I would
over.
initially think hundreds, but I
It's
know
over
people have,
1,100
yeah.
just for Thomas Edison. Sorry, I flipped the. I'm
That's
getting off.
okay. We enjoy it. We enjoy it. It makes
Well, it's
fun.
fun because it's stuff that, like, we're here to learn,
Yeah,
honestly, we are.
Yeah.
no, I get it,
And
and I love
so if
having
you
my
can
mind
teach me
blown. But yeah,
something,
all
I'll
right.
take it.
What's next on the lightning round?
What's one thing every founder should ask their IP attorney?
Mm.
Mm, um, it's not what the IP founder asks the attorney. It's what the IP attorney asks the founder. That's really what it is. The question that a founder should come away with is, do I feel understood? Do they understand my technology? It's not about them qualifying the IP attorney. It's them feeling and understanding, like knowing that the IP attorney has their back and is covering their best interests. That's really what it is.
Love it. What is your favorite startup success story?
I've had a lot of clients that have been pretty successful. Some, obviously, some that haven't, because 9 out of 10 startup companies fail. Um, right now, I would say Rubicon Global is one of the great ones. Trash management, waste management. Um, Fantastically successful company, and I'm proud of them.
I'm gonna allow you not to answer this one, but this is just a question I have. Are there any that you've looked at that any startups that you looked at that failed that you were like, "Man, that should have succeeded. That was such a good idea."
Ooh, yeah. I don't know that I'm going to answer that question because the patented technology is still patented and I think still worth something and should still have legs. So yeah, there's a lot of, but the issue is that like companies don't necessarily fail because the technology isn't good enough. Startup companies often fail because of execution, which is why that first group of VCs has it, from a lot of perspectives, they have it right. What is the team? Have they had successful exits before? Are they learning? Are they going to scramble? Are they going to make things work? Are they going to figure out and solve the problems? And that's usually why the companies that I think like that should have worked. That's why they fail.
Yeah, I would say I agree with that completely. Like, you know, I tell people, like, I use the McDonald's example a lot because like McDonald's does not have the best hamburger, yet they're the biggest burger chain. Their execution is like far none amazing. Their marketing's amazing. Their systems are amazing. They understand real estate game. They understand so many components of what's going on, and very little of it has anything to do with the burger. You know,
That's right.
and it's like,
Well, we
yeah, I
all know it's
think,
about the French fry anyway, right? Like, it's not about the burger. No, yeah. I mean, it is about execution, and it is about making sure that you have all your I's dotted and your T's crossed from a legal perspective, and making sure that you execute.
yeah,
It really is.
yeah, I agree.
I mean, and honestly, the french fries are heaven when they're hot and hell when they're
That's
cold.
right. I agree with you, 100%.
I don't know how you can reach both ends of the spectrum with one piece of food, but McDonald's did it. They should have a patent on that.
Well, they did what they on making it terrible when it's cold.
Yeah, it's like that's their patent.
Yeah. That would be cool. No, I think that but I'm always interested in kind of like the search and the story behind things. McDonald's actually searched far and wide for the right potato to use for their fries, and they found it.
Yeah,
Well, there's a story that in Canada, which is where I'm from, there is a coffee chain, and they've been the biggest coffee chain in Canada for decades.
Yeah,
And
Hortons, right?
Tim Hortons,
Yeah.
yeah, Tim Hortons. There's some of them in the US. I actually live like 10 minutes away from one, so my heart is happy. But they had their coffee. They'd spent so much money finding their coffee, and they let their contract with their coffee supplier expire.
Yeah.
And McDonald's came and bought it up, and now they've got the best coffee in Canada.
Not Tim Hortons. Yeah, I'd heard that. I've got a son who does quite a bit of work out in Canada, and he brings home a bag every once in a while. It's good coffee, but it's not, you know. But he also brings home Tim's Bits, which I think is hilarious, and he loves those.
Timbits are sorry, you're going into my childhood here, so I'm gonna just kinda I could just geek out for a while. Where can our listeners reach out to you if they've got a product that they wanna protect?
Yeah.
Where can they reach you?
Look, our website is at www.rock-ip.com. So rock-ip.com. You can always find me or the firm on LinkedIn. You can email me. Go ahead and email me personally. That's fine. rob@rock-ip.com. Any one of those is a great way to get in touch with us. We've got a podcast called Rock Solid IP. We're revamping it. So, there's some advice on there if you want to check it out, but we're in the process of putting up a new one.
All right.
Nice.
Brandon, do you have any last questions?
Yeah, what products do you think, or what products do you see do the best from your experience, just like in general?
The best products that we see are products that solve a very real concrete problem. One where the inventor or the designer has spotted on some level a problem that legitimately needs to be solved. There's far too many startup companies that come up with a product or a solution to something that it was fine. They're like, or they are trying to create this new niche, and some of those products actually survive. Some of those products do well, but the ones that I think are the most successful are the ones where you kind of like, when it comes out, you go, oh my gosh, of course. Like that is so simple, so straightforward, and I need it, right? Like you recognize an actual need. It solves some problem that
Right.
we all struggle with and makes things a lot easier for everybody. Those are the ones where it's an absolute shoe in.
I completely agree. I actually just had a conversation, or made a connection yesterday about something very similar to this with the manufacturer, and we're all geeking out over it because it's very simple. It doesn't have to be complicated. Matter of fact, most time from a development standpoint, it's the simplest ones that we can push the fastest, and there's the most margin on. But just like, yeah, is it actually solving a problem, or is it another way to skin a cat? Because there's some really good way to skin cats, and you can improve on it, but it's a marginal improvement, and those are hard to sell. But when you're the
Right.
first one to figure out how to skin a mountain lion or what, I don't know.
Yeah.
It's a terrible
No, I get what you're
analogy.
saying. No,
But
that's
when you're the
exactly right.
first one to figure out, or the second one to market that has a much better way than the traditional process, those are the ones that we see really change the market and get that brand recognition.
Yeah, absolutely. And what I would add to that is that it doesn't have to be overly complex. We talk to a
Yeah.
lot of inventors who say like, "Oh, I didn't." It's not. It's common sense. It's obvious. It's like the thing I did is it's pretty simple. And that's what I try to correct. There is like every inventor either really overvalues or really undervalues their invention.
It's a
What I
good way
try
to
to
look at
correct there for those inventors who say like, "Ah, it was obvious," is to say like, no, it's elegant. An elegant solution does not mean that it was easy or obvious. An elegant solution means it fixed a problem that existed, and it does so in a really clean way, right? And that is really valuable, and we all love that.
I love the way you express that, because one of my biggest, I guess the hardest thing is sometimes trying to explain that, like by simplifying it. And like we just did a bracket, and the first version of bracket was quite complex.
Mm-hmm.
And then we did another round, and I turned it into like some very simple piece of bent metal with a hole pattern that mounted up and it cuts on certain angles, but it did everything this complex bracket did. And like his margins just went through the roof. Like there's all these benefits I can show. Like It's super
Everything got cheaper.
manufacturable.
Yeah.
But yeah, I mean, I don't want to get too into it, but it's like, and sometimes a lot of our clients, they don't necessarily understand that their business has a much higher success rate with the second bracket than some fancy bracket, especially when you're not going to see this. Like, the idea is not to see this bracket. It makes two things fit together really well. That's what it needs to do. It needs to make two pieces fit together and hold them securely. So everything else is just cutting your margins.
Right. Well, and marginal improvement is patentable, right? Like if you're making a marginal improvement on something that's already out there, that's okay. That doesn't mean that it's not patentable.
Right.
Let's get into figuring out whether it actually is or not. But you taking the bracket, making some changes to it, figuring out how to make it a little bit better than it was, and doing that repetitively and iteratively. Like, look, that's the story of invention, right? That is the story of how we move from point to point, and that's how the entire world has advanced to the point where we're at right now, right? From the wheel or fire to all the way to quantum computing, is through those small iterative developments. If you even think about Thomas Edison and the light bulb, right? Like, we go, oh my gosh, that was massive leap, and it really was. No, I'm not saying like, oh, the light was not that important, but think about what he ultimately combined in order to get to the light bulb, right? He combined string and carbon on the string and a vacuum and glass blowing and electricity, right? Like, he figured out how to put those things together, things that someone else somewhere had invented, right? Put all those things together. You're in the same boat. You're taking a system that exists, you're refining it and coming up with something that's more elegant, something that might be more straightforward, hopefully something that's cheaper, more robust, maybe, functions better, operates more quickly. Yeah, absolutely patentable. And you take a light bulb. Right now, we've got LED light bulbs that are a far cry from what Thomas Edison had developed. Marginal invention.
So I just want to say thank you. We're actually over time right now. And so I just want to say thank you so much, Rob, for jumping on and letting us have this conversation with you. If you have a product that you want to protect, or a trademark, or a trade secret, or copyright, or whatever it is, if you have IP that you want to protect, go check out Rob at rock-ip.com, or you can send him an email at rob at rock-ip.com. As always, if you want to have a product developed, come talk to Brandon and I at My Product Developer. Again, like, subscribe, and have yourselves a great weekend.